Hello, members. Welcome back to Agora Legis, the platform of legal minds, where we discuss legal principles and make them easy to understand. And today we are continuing with Contract Law 1, and we shall be looking today at the topic of capacity to contract. We shall look at the definition of capacity to contract, we shall look at the legal framework and statutory framework, and also we shall look at the different categories of people who are uh, who are having legal capacity to contract. So without further indulgence, I'm Counsel Ben, and let's jump right in. Start with the definition. It is defined by Professor Ben Twino Mugisha Kiromba, who defines it in his book Principles of Law of Contract, and he has defined capacity to contract as the legal competence of a person to enter into a binding contract. So here, members, we are looking at what makes someone able to enter into a valid contract. And we have seen earlier on uh, under definition of a contract that capacity of a contract is one of the key elements when we are talking about formation of a contract. So who has the capacity to contract and what is the competence needed for someone to enter into a valid and binding contract? The rationale behind this principle, members, is to protect the people who may not have full understanding of contractual obligation and their consequences and the nature of those obligations, and to protect them from exploitation. People such as minors, people who are mentally incapacitated. So that's the first rationale. And the second rationale is to enhance certainty in commercial transaction. After seeing the rationale of this principle of capacity to contract, we shall now look at what is the statutory framework governing capacity to contract. And it has been codified in the Ugandan legal framework under several statutes such as the Contract Act Cap 284, such as the Sale of Goods and Supply of Services Act Cap 292, and under the Contract Act, it is found under Section 10, where they provide the prerequisites for a person who is supposed to have capacity to contract, including age. Someone has to have 18 years and above. Sound mind. The person should not be of unsound mind. And thirdly, the person should not be excluded by any other law or disqualified by any other law to which he or she is subject. The same is provided under Section 4 of the Sale of Goods and Supply of Services Act, Cap 292, looking at the general rule as to the capacity of contract and the prerequisites. We shall now look at categories of people under exceptions of people who may have that capacity to contract under particular circumstances. And we shall start right away by minor. A general exception under Article 34, Clause 5, says that the, the economic protection of minors and children uh, does not include the children over or minors over 16 years. So normally, in normal terms, uh, children and minors are not supposed to be employed, are not supposed to be exploited in any way or the other. But this doesn't. But the children referred to in clause 4 of this article do not include children above the age of 16 years. And the first exception here includes contract with whose subject matter include or involve necessaries for this minor. So a minor is bound by a contract which includes necessaries for him. What do we call necessaries? Necessaries are goods and services which are suitable and necessary for the condition of life of that minor in particular. Here we are talking about something like food, we are talking about something like shelter, we are talking about something like education. So once the contract includes necessaries for that minor, the contract is binding for both the minor and the other contractor and will be legally enforced in case of breach. As far as that principle is concerned, we have reference to the famous case of Nash versus Inman. Following contracts including minor, which can be imposed by law are contracts which are beneficial to the minor. For example, contract of apprenticeship, uh, professional training, education. This once a contract involves the earlier cited, that contract is binding in law, and the minor would be bound in case of breach. This has been applied in the case of Clement versus London and North Western Railway Company Limited. Lastly, about minors, uh, the avoidable contract at the option of the minor if the contract includes property, investment, and continuing obligations. Second category of people who may have capacity to contract under the contract law is an exception to the general rule of the capacity to contract are people with unsound mind. So what do we call sound mind first of all? According to section 11 subsection 1 of the Contract Act cap 284, sound mind is defined as the capacity to understand the nature and obligation and consequences of that contract and forming a rational judgment as far as his or her interests is concerned. So here members, we are looking at the fact that people who are of unsound mind, in which circumstance may they have that capacity to contract? Under subsection 2 of section 11 of the Contract Act, it is provided that if that person is normally of unsound mind, but at some interval, he has some lucid interval. During those lucid interval in which he is not of unsound mind, he is able to contract and will be bound by any contract in which he enters into as far as he was in that lucid interval. Under the same section, under subsection 3, we have the fact that now here, people who are normally of sound mind, but in some interval they can have unsound mind, any contract in which they enter at the time where they are of unsound mind, that contract is void under the law. This has been upheld in the case of Imperial Loan Company by the Storm. After looking at persons with unsound mind, we shall now look at the corporate capacity. What do we call corporate capacity? We call corporate capacity the capacity to contract of corporate bodies. This is the main companies. So a company, as long as it is registered, it is recognized in law as a person fully with full capacity to contract. This has been upheld in the case of Solomon or the Solomon. Lastly, members, we have government and public bodies, and their capacity is subject to constitutional limitation, procurement law, and public financial requirements. So a contract which goes beyond statutory authority may not be enforceable. That's it for today, members. We have looked at the capacity to contract. I hope you have grasped the principle. I urge you to like, subscribe, and share. That is the only way you can uphold this vision and this mission that you have to share legal knowledge. Thank you for watching. It's always Agora Legis with Counsel Ben.